Good afternoon, everyone, and greetings. Welcome to Eckstein Hall and to our Lubar Center. My name is Joseph Kearney, and it's a great privilege for me as Dean of Marquette University Law School to introduce our Hallows Lecture. I like to begin by recalling the person in whose memory this lecture stands. E. Harold Hallows was a native of Fond du Lac, Wisconsin, who practiced law in Milwaukee from 1930 to 1958. Throughout this time, even to omit his other connections with Marquette University, Hallows taught part-time at Marquette Law School. Every Tuesday and Thursday at 8 a.m., a generation of future Marquette lawyers took equity and equity 2, required courses at the time, from Professor Hallows. Hallows was also a most engaged public citizen, especially in matters involving law reform and the courts. In 1958, when Roland Steinle, a Marquette lawyer, stepped down from the Wisconsin Supreme Court, Governor Vernon Thompson appointed Hallows to succeed him. He was then elected in 1959, and in 1969, as Chief Justice, was re-elected, serving until his death in 1974. This was a most dynamic time in legal doctrine. No less important was Hallows' work as Chief Justice in promoting the court reorganization that in the 1970s gave us the modern Wisconsin judicial system. In short, whether as a practicing lawyer, a law professor, or a justice of the court, E. Harold Hallows, for more than 4 decades, was at the center of things in Wisconsin's legal profession and community. It was to celebrate and recall all aspects of his career that Marquette Law School in the 1990s created this annual lecture. Our lecturer this year, the Honorable Michael Scudder, comes to us from Indiana by way of Chicago with some stops in between. He is a native of Fort Wayne, attending college at St. Joseph's in Indiana, and then after a stint as a CPA, he graduated from Northwestern University School of Law. He clerked for Judge Paul Niemeyer of the U.S. Court of Appeals for the Fourth Circuit and for Justice Anthony Kennedy at the U.S. Supreme Court. Michael Scudder's legal career has included extensive work on the East Coast in the U.S. government, both the Department of Justice and the White House Counsel's Office, and in private practice with a large international firm in Chicago. Since 2018, he has been a judge of the U.S. Court of Appeals for the Seventh Circuit, while also teaching courses in advanced federal jurisdiction at Northwestern University and national security law at the University of Chicago. Judge Scudder is nationally known, but especially embraces the opportunities presented in the tri-state region of the Seventh Circuit. And for several years, we have been doing our best to bolster his Wisconsin cred to go along with the more obvious claims to Indiana and Illinois. That latter is to say that he has visited us before, and it was on an informed basis that he accepted the invitation to deliver this year's Hallows Lecture. For that lecture, Judge Scudder has elected to speak about resorting to courts, Article 3 standing as the guardian of free speech and democratic self-governance. Won't you please welcome back to Milwaukee and Marquette Law School the Honorable Michael Scudder.
Thank you, Dean Kearney, for your gracious introduction. Thanks to Marquette for the honor of delivering this year's Hallows Lecture. I appreciate very much Marquette's warm hospitality, the alma mater of Diane Sykes, a superb jurist and a great leader of our court. I give this lecture nearly 7 years after joining the federal judiciary and at a time of deep political division in our country, and as someone who loves the law of federal jurisdiction. My observations from my time on the court and in light of our current divisions combine to inform the content of my remarks, and I want to begin by describing an appeal the Seventh Circuit decided about a year ago in March of 2024. The appeal helps inform and frame the title and topic of my lecture, as you just heard, resorting to courts, Article 3 standing as the guardian of free speech and democratic self-governance. In 2021, here in Wisconsin, the Eau Claire Area School District developed and issued administrative guidance for gender identity and support. The guidance, as its name implies, embodies the school district's policy and direction to member schools encountering students with questions about their gender identity. In its own words, the policy sought to provide schools with guidelines and a resource to follow when addressing questions and requests for assistance from students or parents on matters of gender identity. The administrative guidance acknowledges the difficulty and sensitivity of the issues relating to gender identity, and by its terms recognizes that some students may not be open at home for reasons that may include safety or a lack of acceptance. It was for that reason that the guidance tells principals and school counselors that they should speak with the students first before discussing a student's non-conforming or transgender status with the student's parents or guardian. In implementing the guidance, schools may complete what the policy calls a gender support plan. Here too, the guidance states that school staff, family, and the student should work together to prepare individual plans. And the school district further committed to providing parents with a copy of any support plan developed for their children. A group of parents came together, formed an association called Parents Protecting Our Children, and challenged the school district's policy in federal court in Madison. The association brought their suit under Section 1983, a federal statute providing a cause of action against municipalities and state officials for violations of federal rights. The association alleged that the administrative guidance violates its members' substantive due process rights as parents under the 14th Amendment, as well as the free exercise rights of parents under the First Amendment. The association acknowledged that it brought its claims not in response to any experience any parents had with the school district's implementation of the guidance, but instead as a pre-enforcement facial challenge. The central allegation was that the new policy would operate not only to sow secrecy and mistrust between parents and their children, but also to displace their parental rights by allowing school officials to make major life decisions for their children. The complaint asked the district court for a broad remedy to declare the school district's policy unconstitutional in all of its possible applications and to enjoin its use in the Eau Claire schools. The district court dismissed Parents Protecting's complaint for lack of standing, and the Seventh Circuit affirmed. By way of full disclosure, I was on the 3-judge panel and authored the court's opinion. Agreeing with the district court, the Seventh Circuit concluded that the association lacked Article 3 standing because, in the words of our opinion, nowhere does the complaint allege that even one of the association's members, any particular parent, had experienced an actual or imminent injury attributable to the administrative guidance or a support plan. And without such allegations, the court reasoned, the association presented no case or controversy within the meaning of Article 3 of the Constitution, leaving the district court without subject matter jurisdiction. The district court's only choice was to dismiss the complaint. In affirming the dismissal, the court offered a few observations pertinent to today's lecture. Our opinion observed that Parents Protecting's complaint, while plainly brought in good faith and rooted in genuine concerns about potential applications of the policy, contained no suggestion that any parents had approached the school district or any school administrator to discuss plans for implementing the administrative guidance. The court instead saw the lawsuit as coming, as our opinion put it, as the ink was still drying on the new policy and reflecting what seemed like an effort to pull a federal court into a range of complex and often emotional challenges on matters of gender identity, where the right policy recipe is not yet clear and the best answers are sure to come in time through the experience of school students and families. In these circumstances, the court saw Article 3's case or controversy limitation on federal jurisdiction as leaving no choice but to stay on the sidelines and to await, if the day came, a concrete dispute about a specific application of the administrative guidance. No doubt believing our view was mistaken, Parents Protecting sought review by the Supreme Court. The court declined, but 3 justices dissented from the denial of certiorari, with 2 justices writing separately to say the appeal warranted the High Court's attention. So there you have it, a controversial, socially divisive issue that an associational plaintiff brought to federal court seeking broad pre-enforcement relief, a court of appeals affirming a dismissal for lack of Article 3 standing, and 3 Supreme Court justices expressing interest in reviewing the decision. Beyond the law professors and practitioners in Eckstein Hall this afternoon are many law students. If I paused and randomly called on a few of you to tell me what issues you see in a case like Parents Protecting Our Children, and I see you there in the back, I'm not about to do that, I bet you would nail it. Whether you believe the Seventh Circuit got the decision right or wrong, I expect many of you would say the appeal raises hard questions about the competing interests between parents and schools and implicates structural considerations of federalism. And a real legal eagle would tell me to be more careful with my word choices in describing Parents Protecting as a case, because after all, the absence of Article 3 subject matter means there is no capital C case within the meaning of the Constitution. Those observations would be right, but I wonder how many of you would go another step or two and see the Parental Association's lawsuit as implicating the role of free speech in our constitutional design, or, to put the point in broader terms, as implicating the relationship between the First Amendment and Article 3's case or controversy requirement. That's the issue I want to explore in this lecture. While Parents Protecting's case provides a helpful example to frame our discussion, my broader observations today extend well beyond the decision to considerations that have been on my mind for a while about the relationship and role of federal courts and free speech in our constitutional democracy. Allow me to start with background common to most, if not all, perspectives on this broader question. And maybe some of this legal foundation will help those of you about to stare down a federal court's exam here in the coming weeks. Article 3 of the Constitution extends the federal judicial power to particular cases or controversies. In this way, federal courts, from the Supreme Court to, in the words of the Constitution, all inferior courts that Congress chooses to create, including the one I serve on, are courts of limited jurisdiction. Unlike state courts of general jurisdiction, federal courts must ensure the presence of a case or controversy to act. While our courtrooms are public and open to all, our dockets cannot accept all comers. The Constitution limits us to resolving concrete disputes between adverse litigants, cases or controversies, as Article 3 calls them. The justiciability doctrines of standing, mootness, and ripeness, and the related prohibitions on resolving political questions and issuing advisory opinions give effect to this limitation. Today's law students learn standing doctrine by reading cases like Lujan versus the Defenders of Wildlife and committing to memory the three elements of what the Supreme Court has called the irreducible constitutional minimum of standing. The requirement that a plaintiff allege, and in the course of litigation establish with evidence, that they've suffered an actual or imminent injury, one that is not hypothetical or conjectural, traceable to the defendant, and capable of being redressed through a favorable judicial ruling. Scores of other cases tell us that the law of Article 3 standing is built on a single basic idea, the idea of separation of powers. And this structural principle of separation of powers, the Supreme Court has emphasized, was not simply an abstract generalization in the minds of the framers. It was woven into the document they drafted in Philadelphia in the summer of 1787. I worry that too many today, foremost non-lawyers, hear descriptions like these as poetic and lofty, idealistic and aspirational, not relevant or practical. For others, I worry that talk about structural constitutionalism, separation of powers and federalism in particular, invites nothing more than bumper sticker level labeling and categorizing, with so-called judicial conservatives being interested in such ideas and so-called judicial liberals more focused on individual rights. If I could lodge one request with the law students here today, it is to resist these categorizations. Standing is not a conservative invention any more than a belief in federal courts as protectors of individual rights is a liberal invention. Characterizations like those are reductive, empty on many levels, and tend to force foundational elements of constitutional law into binary, mutually exclusive categories. A dialogue limited to, if not insistent on, liberal and conservative compartmentalization breeds skepticism and cynicism about law and the proper role of courts in our constitutional democracy. Let me emphasize the point by returning for a few minutes to the US reports. And let's start with the Supreme Court's 1992 decision in Lujan versus the Defenders of Wildlife. The court held that environmental groups lacked standing to challenge a federal regulation on the ground that it violated a provision of the Endangered Species Act. In law school and many times since, I've heard Lujan dubbed as an anti-environmental conservative triumph for the Rehnquist court. I've heard much the same about Clapper versus Amnesty International. The plaintiffs were a group of human rights lawyers concerned that the government, as part of conducting electronic surveillance pursuant to the Foreign Intelligence Surveillance Act, would monitor their phone calls with their clients. The court held that the lawyers, who did not actually know whether the government was monitoring their calls, had not alleged an injury, actual or imminent, under Article 3. Many seem to label Clapper as a win for conservatives and national security and a loss for liberals, privacy, and civil liberties. By those measures, I think the same observations apply to Los Angeles versus Lyons, a must-read for all law students, in my view. Lyons is difficult, as everyone reading it empathizes with its plaintiff, Adolph Lyons. A simple burned-out taillight led to a Los Angeles police officer pulling him over and placing him in a chokehold that left him gasping for air, spitting out blood, and blacking out. And LAPD at the time had a history of subjecting African-American men like Mr. Lyons to these types of chokeholds. So Mr. Lyons invoked Section 1983 and he sued the city. seeking not only compensatory damages for his injuries, but also declaratory and injunctive relief to bar LAPD's future application of chokeholds. The justices had no difficulty concluding Mr. Lyons had Article III standing to pursue money damages, but a majority held, over vigorous dissent, that he lacked standing for equitable relief because he could not establish a likelihood of future injury, of being subjected to another chokehold by LAPD. The court's dismissal of Mr. Lyons' request for injunctive relief, I've often heard it said, marked a victory for law and order and a loss for civil rights. As you might expect, and as the court observed in its opinion, the LAPD's use of chokeholds resulted in major civic controversy, with a spirited, vigorous, and at times emotional debate, with people speaking up and voicing their concerns and perspectives about local police tactics. From what I can tell, the police department quelled the concerns by imposing a moratorium on the use of chokeholds, without any federal court ordering them to do so. Applauding or criticizing Lujan, Clapper, and Lyons as conservative wins and liberal losses might make for good sound bites, but in my respectful view, that labeling misses the true mark and risks the ideological pigeonholing of law. The more complete and compelling view comes from seeing the decisions as structural, as giving effect to Article III's limitation on the exercise of judicial power to cases or controversies. To borrow a phrase, let's be more concrete in particular. Lujan, Clapper, and Lyons are about federal courts requiring the presence of an injured party or someone facing an imminent risk of injury before passing on difficult legal questions. If I've not convinced you, allow me one more chance. 2 opinions from the Supreme Court's last term may help persuade you. Consider first Murphy versus Missouri, a case in which the plaintiffs, 2 states and 5 individual social media users, alleged that federal executive branch agencies and officials pressured online platforms to enforce their content moderations against speech that many would regard as ideologically conservative, including, for example, criticism of vaccine mandates. They sought a broad injunction to limit executive branch communications with the platforms. But the Supreme Court concluded that the plaintiffs' alleged injuries were not redressable because they stemmed from the independent actions of the platforms, third parties not before the court. Article III standings doctrine, the court emphasized, prevented a federal court from exercising oversight over a coordinate branch of government, the executive branch, in such circumstances. Next, consider FDA versus the Alliance for Hippocratic Medicine, often referred to as the mifepristone case. As you can probably guess from the case's shorthand name, it involved the FDA's approval of an abortion-inducing drug. Yet the court did not address the merits, instead concluding that the plaintiff doctors and medical associations lacked standing to challenge the FDA's approval of mifepristone. Since the plaintiff doctors were not prescribing and did not have to prescribe mifepristone, what the plaintiffs were really challenging was the authority of other physicians, non-parties to the lawsuit, to legally prescribe the drug. To permit the lawsuit to proceed, the court worried, would risk giving any citizen standing to challenge any government action they found objectionable, rather than presenting those objections to, as the court put it, fellow citizens, including in the political and electoral process. For reasons obvious to all, many headlines cast Murphy in the mifepristone case as liberal wins and conservative losses. But do not sign me up for that view. The court resolved both cases not on the merits, but instead on jurisdictional grounds rooted in structural reasoning. I believe you received an outline of my lecture as you entered Eckstein Hall. If you're jotting down these cases I've mentioned in keeping score of winners and losers, the winner sure seems to be structural constitutionalism. One broad takeaway is that Congress, the executive branch, and state and local government, not federal courts, are the proper outlets through which to address these issues and, by extension, resolve grievances. Put another way, I think it's too shallow, if not misdirected, to put these cases in win-loss columns based on what we perceive as conservative, liberal, or some other ideologically measured outcome. Well, is my sample set too limited and perhaps a bit cherry-picked? That's fair at some level. Can't outcomes be explained along multiple dimensions? Yes, that's fair too. Am I trying in these thoughts to offer a unifying theory of all of Article 3 standing law? No, definitely not. I view my point as more limited to observing that structural constitutionalism best explains all, or at least major portions of these significant standing decisions. By no means am I the first to consider these issues. Lots of ink has been spilled on Article 3's case or controversy requirement and its structural implications within the Constitution's broader design. Law journals are loaded with insightful commentary, and I'm grateful for the opportunity this lecture has provided me to break away from my daily diet of reading briefs, morning, noon, and night, often. The Academy has a lot to offer us as judges, and for that, I'm thankful. As part of my brief foray into the Academy here today, I want to offer my own perspective on a structural dimension of Article 3 standing doctrine that's present between the lines of some court decisions and much commentary, but not expressed on the surface. Let's go back to the beginning in the Seventh Circuit's decision in Parents Protecting Our Children. To read the decision is to see the social controversy underpinning the Parent Association's claims challenging the Eau Claire School District's gender identity policy. You might see the case as a culture war dispute. Taken to federal court, a postcard example of litigation raising difficult and socially divisive questions about parenting and gender identity in public schools. In no way should you hear 1 ounce of criticism in anything I'm saying. To the contrary, and as the Seventh Circuit emphasized in its opinion, Parents Protecting clearly brought its claims in good faith and out of genuine concern about the administrative guidance and how local schools may implement it. And so too was it clear that the school district promulgated its policy to avoid its member schools getting caught flat-footed or making mistakes on delicate and difficult subject matter. In explaining why the Parents Protecting Association lacked Article 3 standing, the court offered a few observations apt to the perspective I now come to in the lecture. Nowhere in the complaint or any of the parties' briefs did the court see, as our opinion observed, any indication that any of Parents Protecting's members asked the school district how it planned to implement its guidance. Instead, the lawsuit leveled a pre-enforcement challenge to the school district's policy, urging the federal court to declare the policy facially invalid, root and branch unconstitutional in every possible application. Yet facial invalidation of law, the Supreme Court has emphasized, is highly disfavored, and as our opinion sought, especially so, whereas here the relief sought implicates a local policy and weighty principles of federalism. By way of contrast, just last month, the First Circuit grappled with a very similar gender identity policy except that this lawsuit was brought by two parents challenging a concrete application of the policy to their child. Nobody disputed the parents had standing, and the court resolved the case on the merits. The parents' protecting decision, however, I would submit, is about a federal court trying to stay in its lane, about taking care to insist on a concrete dispute between adverse litigants, about making sure the right parties are before us before reaching the merits of legal questions of substantial consequence, and about considering whether the proper parties are seeking the proper relief. Consider a few questions that would have taken center stage had the court concluded that the Association of Parents did have standing, and from there reach the merits of their constitutional challenges to the administrative guidance. Do principles of substantive due process, and the right to parent in particular, preclude local school districts from even attempting to provide guidance to principals and counselors on how to address matters of gender identity? If the answer is no, do school districts have any discretion in extraordinary circumstances to consider the safety of a student in determining whether and when to communicate with the student's parents about these issues? On the other hand, if the school district's policy is constitutionally problematic on its face, what principles should guide the necessary tailoring analysis? For my 2 cents, these are hard questions, and ones a federal court ought to be hesitant to wade into unless and until an imminent or concrete injury and challenged application of the gender identity policy presents itself in a complaint. So, Article 3's case or controversy requirement worked to return these difficult questions to the Eau Claire School District, and even more specifically, to the district school board, which meets in public and permits school officials, parents, and other interested parties to raise questions and share perspectives. It's in this very practical way that Article 3 promotes democratic deliberation and federalism by channeling questions and concerns about potential applications of a local policy and perhaps suggestions for modifying, clarifying, or even repealing it back to the meeting room from which it emerged. This is how Article 3's limitation on the exercise of judicial power leaves policymaking and the difficult line drawing it often entails to the exercise of free speech. Speaking up, objecting, and sharing perspectives with those who differ from us is how we understand, persuade, and often find common ground where agreement seems beyond reach. If that framing is too idealistic in today's times, I would hope skeptics would at least recognize that the alternative, permitting very difficult legal questions to come before a federal court based only on a showing of genuine worry, casts a vote of little confidence in the role speech can play in finding solutions and perhaps tolerable compromises to some of the most divisive questions of our day. And even if these culture war lawsuits should not be viewed as a vote of confidence in federal courts as ultimate decision makers, they put great pressure on principles of restraint designed to allow democratic processes, whether at the national or local level, to offer answers and outlets for persuasion and compromise in the first instance. Our constitutional design envisions constitutional answers coming in slower paced increments than contemplated by pre-enforcement challenges like the one parents protecting our children lodged against the Eau Claire policy. It's not happenstance that the architect who designed the Supreme Court of the United States, Cass Gilbert, thought the tortoise an appropriate and decorative symbolic feature for the building's design. In the same way tortoises move slowly, sometimes the law develops best when principles, doctrines, and answers come with time, and I might add, with more speech and dialogue, helping to bridge social divides. Pre-enforcement facial challenges, however, often result in expansive injunctions that apply in one fell swoop, the sort of forward-looking policymaking that's best left to more democratic branches. The premature injection of a federal court's decision-making authority on a matter of state or local importance risks not only chilling free speech, but also painting with too broad a brush. The Eau Claire School District may elect to navigate the delicate issue of student gender identity in a matter which completely differs from the next town over, let alone the next state. And that's exactly the point. Federalism both permits and promotes the adoption of different solutions to the same challenges. And over time, states, local governments, and school districts operating as laboratories of democracy, as Justice Brandeis coined the phrase, might arrive at the best solution. But where a federal court intervenes with no case or controversy to resolve, our constitutional structure does not operate by its federated design. Do not hear me to be questioning all pre-enforcement or facial challenges. Far from it. Take, for example, the overbreadth doctrine, which allows challenges to a restriction on speech not as applied to a particular plaintiff, but because the restriction may apply to others in ways that limit or chill protected speech. If that sounds at odds with my description of the rules for Article 3 standing, thank you for staying awake. Because yes, overbreadth doctrine in some ways is an exception to those rules. So I have an overbreadth doctrine. Foremost, because the law wants to protect and promote speech, and it will allow what otherwise might seem like a premature lawsuit to achieve that end. Overbreadth doctrine's remedy, declaring a statute facially invalid, returns the ultimate question to lawmakers, promoting the judiciary's proper role. So overbreadth doctrine, too, is structural in this way. Parents protecting our children is not an aberration in federal courts today. In conducting my own research, I found many cases of federal courts receiving pre-enforcement and often facial challenges to federal, state, or local policies on a range of matters fitting the culture wars label. Restrictions, for example, on school policies regarding sexual orientation, the content of libraries, course offerings, vaccine mandates, and student loan forgiveness programs. I'm not suggesting one or another lawsuit on these topics is problematic, inappropriate, or not justiciable. What I am observing from my experience thus far on the Seventh Circuit is that culture wars litigation is a reality of our times. I'm curious why these culture war disputes find a federal courthouse more attractive than discourse and dialogue. I have no doubt many factors explain the observation. And at this point, some of you are surely thinking the answer is obvious. Dialogue on issues like gender identity, library collections, and public school course offerings leads to dead ends, stalemates, if not shouting matches, literally or electronically, between mutually exclusive perspectives. Genuine dialogue, many reactions may run, seems so very scarce in America today. Part of the reaction I get. Yesterday's image of the public square, Norman Rockwell-like gatherings of people coming together to discuss, debate, and find common ground on questions about local affairs seems absent if not unrealistic for many. Pause and ask yourself the last time you experienced anything like that. I bet your list is short. So much of our communication today does not occur in groups of any kind, much less with members of our communities. Quite the opposite. Most of our interactions occur when we're communicating alone. Each of us by ourselves sending and receiving information on our phones, tablets, and computers. Look around the next time you're in a coffee shop, restaurant line, airport lounge, or riding the bus, and notice how many people have their heads buried in a screen. I would plead guilty to this observation many times over. It's not a point of criticism. I'm more highlighting the magnitude of the challenges upon us as a people, as communities, and as a nation for the role and path of speech as the recipe for answering today's most difficult, socially divisive questions. In preparing for this lecture, I learned that these same observations, made by many others, are what spawned an entire area of study on the decline of civic engagement, community connectedness, and social discourse in the last several decades. Harvard political science Robert Putnam seems to have minted many of these observations in Bowling Alone, a book I've had a hard time putting down. Putnam focuses on the social isolation and fragmentation that has gripped much of America, our limiting communications to those with similar views, and our hesitancy, if not unwillingness, to form social connections with those holding different ones. Bowling, Putnam observed, has remained popular, but with many no longer joining a league or team and instead preferring to bowl alone, much like the declines we've seen in people attending religious services, joining the Rotary Club, the Scouts, or the Card Club. This trend has resulted in what Putnam calls a loss of bridging social capital, which has manifested itself in less democratic participation, among many other negative consequences. From my own perspective, we see this loss of bridging relationships, if you will, in many unfortunate ways today. Communicating so much less in person and so much more electronically with each other has brought with it the incivility we see in today's discourse. Too many people write things in a text or post that they would never say to someone in person. Stepping back and thinking more broadly about the state of speech today, I have a hard time seeing much reality in Justice Holmes's famous metaphor, the marketplace of ideas. Justice Holmes invited us to see the exchange of ideas in a democratic society as a marketplace where speech comes together in ways that allow facts to disprove lies, good ideas to win out over bad ones, understanding to clarify confusion, and tolerance to defeat intolerance. Justice Holmes viewed speech as occurring within settings, be they the community square, meeting hall, local diner, or a neighbor's living room, where bridging social capital, as Robert Putnam would put it, was being built and deposited. Don't get me wrong, I want to see speech in these terms, but I'm doubtful the marketplace of ideas metaphor has much reality in today's socially isolated times. To my mind, it seems much more accurate to see ourselves as living and communicating in different marketplaces. And if there's utility to adhering to the analogy, I'd go a step further. I tend to think that most of us have created our own marketplace, where we communicate and by and large define what speech enters and what speech to transmit and push out. Indeed, we might even think of those marketplaces as little fish bowls. We confine ourselves within and populate as we choose, with our own news favorites, our own messaging feeds, and our own groups of friends and followers. Once again, my observation is not all criticism. Indeed, I think a lot of this comes from necessity. Today's internet age, at the risk of understatement, is not like yesterday's town square. It's more like a massive ocean, full of more water than we can grasp or measure, always producing waves and storms and leaving us feeling adrift. Our shopping carts, to add yet another metaphor, feel overloaded and the market too big, too packed, open too many hours each day, leaving us not sure how to participate. Those practical realities, at least as I see them, help explain why many create fishbowls or echo chambers. They feel easier and safer. But we achieve this tolerable equilibrium for ourselves only by limiting speech, putting ourselves into a space where our ability to stay afloat comes from reducing the range of information and perspectives we consume. What often results then is skepticism and cynicism, and at times what seems like tremendous mistrust of public officials, fellow parents, and neighbors. Bridging divides, brokering compromise, and striving for middle ground seems bygone. Let me try to bring all this together with some observations I've formed since joining the federal judiciary and hearing appeals like the one presented in Parents Protecting Our Children. By limiting the judicial power to the resolution of cases or controversies, Article 3 empowers Congress and the President at the national level, and it leaves matters closer to home to state and local governments. This is how we structured our democracy, with the Constitution creating a limited role for the federal judiciary. Fulfilling that responsibility is not about preferring the right lane or the left lane, and definitely not about promoting or pursuing any particular outcome, but about resolving only concrete disputes between adverse parties. Keeping the federal judiciary in its designated lane promotes democracy by limiting the authority of the least democratic branch to weigh in on concerns better reserved for law and policymakers, and by extension, we as people through our speech. Oftentimes, of course, parties can establish standing, and the judiciary will find itself smack in the middle of a matter of great social controversy and consequence. That comes with the job, if not our oath as judges. To restate the point in legal terms, federal courts, as the Supreme Court has emphasized, shoulder a virtually unflagging obligation to exercise the jurisdiction given them by Congress. No doubt that general precept is correct, but recognizing an obligation is not the same as knowing whether it applies in a particular circumstance. Indeed, in preparing my remarks today, I learned that the Parents Protecting decision itself generated ample commentary, with some thinking we got it right and others thinking we did not. I'll leave it to each of you to decide where you stand on that question. And yes, that pun was intended.
Sure.
My own takeaway is to reinforce what I see as a relationship between Article 3's case or controversy limitation and the role of speech in our constitutional democracy. By staying in their lane, federal courts leave certain matters to us as people to resolve in the first instance. Many times, the resolution comes through the roles played by elected representatives, selected by us as voters based on the issues facing our nation, states, and local communities. Yet at other times, we can and should voice our perspectives more directly by attending a city council, school board, or any number of other policy-making meetings. By attending and speaking up, we exercise a right our Constitution not only protects, but as a structural matter sees as essential to the operation of our democracy. It misses the mark, in my respectful view, to see a decision like parents protecting our children as misapplying a conservative legal doctrine, Article 3 standing, to deliver a loss to an association of conservative parents genuinely concerned about the promulgation and potential implementation of a liberal gender identity policy. The decision is better seen as a court respecting Article 3's limitation and leaving, at least for the time being, questions about the application of the policy to ongoing dialogue, or perhaps robust questioning in school board meetings or one-on-one meetings with parents, principals, and counselors. Another observation may rush to mind for many of you. I very much sense that some today may feel the biggest challenge is not so much individuals speaking up, but getting policymakers to listen, empathize, and show a willingness to find common ground. That too may be right. For there's no doubt our democracy is as complex as the challenges that face it in today's times. But one thing I believe for certain, the solution cannot be to give up on speech altogether. Is the path forward here easy or comfortable? Not by a long shot. Culture wars are very real, and the concerns underpinning them often challenging and emotional. Perhaps what concerns me most is how we as people in today's times tend to approach them, not by leaving our self-selected echo chambers and engaging with each other on a new idea, or maybe just enough to find a tolerable solution or compromise. And if we do leave our fishbowls, I worry our first instinct is to race to a federal courthouse, shortchanging the prospect of speech as a means through which to effect change in our democracy. We can make that choice, but Article 3's case or controversy requirement may leave a federal court with no choice of its own but to stay on the sideline. My modest hope for this lecture is no more than inviting you to see the limited role the Constitution reserves for federal courts as explaining why, at times, answers to hard questions must come through speech, by using our voices to press for change or compromise. In the end, then, for me, it's all about reinvigorating our sense of community, attending the local meeting, and engaging in respectful and informed dialogue. That's the recipe we endorsed in 1789, and it's the one we need to reinvent in 2025 by investing in relationships to bridge our many social divides. Let me restate the invitation in terms more near and dear to Marquette Law School. The namesake of today's lecture, as we know, E. Harold Hallows, served as a Chief Justice on the Wisconsin Supreme Court and a beloved law professor at this great law school for almost 30 years. As I read the tributes to Chief Justice Hallows published after his passing, what stood out most was not this or that about his jurisprudence or scholarship, but an observation about how he lived his life, fully engaged. As a practicing lawyer in Milwaukee, he played an active role in local, state, and national bar associations, as well as on a range of civic, charitable, and religious organizations. He used his talents and, importantly, his voice to shape and better his community. Let this be the great example that inspires us today. Thank you again for the opportunity to share these thoughts with you.
Thank you to Judge Scudder. We have time for a few questions, and we do this usually by people raising their hands and getting my attention, and we will start with you. We only have a few minutes, so please keep your question short, and please keep your answer short, too.
Quick question for you, the advanced federal jurisdiction professor, toughest course in law school. If this case had been started in a state court of general jurisdiction that didn't have limited jurisdiction, it theoretically could have gone its way. What happens when it then reaches the U.S. Supreme Court, which, because Section 1983 has dual jurisdiction in state and federal courts, is the U.S. Supreme Court entitled to hear a case, notwithstanding that it doesn't have a case or controversy fundamentally?
You want to answer? Or you want me to? How about somebody in the back?
Right, one of our students, to be sure. I'll let you do it as I would with Mr. Schreiner if I were in the classroom together. There's a reason that I always have someone up here with me at the time. Do you want to say something?
I think the short answer is this. The United States Supreme Court always has to ensure itself of a case or controversy before it. So if the court concluded that there was no standing, no injury, even if the lower court, a state court, for example, passed upon it on the merits, the U.S. Supreme Court would have to dismiss it for a lack of jurisdiction.
So the state Supreme Court would be the end of that case, notwithstanding the federal issue under Section 1983.
Right. It's difficult to put this in the abstract without the particulars of a case, if you'll pardon me the term, before one. There certainly are cases, though, that unfold in state courts that then cannot be maintained in the United States Supreme Court for want of the Article III jurisdiction that the court always has to have. But it's going to vary according to the particulars. Other questions or observations? Yes, please. Can you speak? Christine is going to give you the microphone.
People may be aware of this, but Robert Putnam, one of my favorite authors, there is a new Netflix out, Join or Die, which is along the theme, and people may want to check it out.
We'll make a Netflix series out of Judge Scudder's visits to Marquette University
my only
Law
response
School.
Is if you don't know Robert Putnam, I can't promote anything, but Robert Putnam is a very smart individual that will really get your wheels turning about the way things are happening or not happening in America today. He's a very, very gifted writer, and he's super articulate.
So we like to do these events in the Lubar Center within an hour, and then we have a public reception in the Zilber Forum right outside. And so given that I do have a few thank yous to extend, we will end the questions here, although Judge Scudder will be out at the reception. And I want to extend a number of thank yous, in particular, of course, to all of you for being with us this evening. This is an extraordinary group here at the Lubar Center at Marquette Law School. And I want especially to thank Judge Scudder for coming up to Milwaukee and being with us once again and delivering really a wonderful Hallows Lecture, much for us to think about. And I'm going to take him out to the Zilber Forum pretty promptly, lest he get trapped at the podium here, but I know he's eager to meet as many of you as possible. And so please join us outside. Thank you.